The origins of bilateral investment treaties. Tracing back the origins of bilateral investment treaties, known as BITs, is not an easy task nor a mission without rewards if done thoroughly. Often relegated to the introductory chapter of books on investment law, this subject is rarely addressed in detail. Hence, its impact on contemporary practice is entirely overlooked. Contrary to common belief, BITs do not originate directly from friendship, commerce, and navigation treaties, known as FCN treaties. This is even more true for European BITs. The so-called bilateral conventions of establishments are instead the direct precursors of BITs. These conventions were concluded between the 19th and 20th centuries to establish and safeguard the rights of foreign nationals with respect to their property, approximately around the same period during which FCN treaties were also negotiated. However, unlike the FCN treaties that dealt predominantly with trade and shipping, the conventions of establishment were meant to encourage mutual investments between states through the so-called establishment provisions. These provisions stipulated the right of nationals of a country to establish and carry on business activities within another country and to receive due protection there for their persons and property, thus effectively creating foreign investors' rights. FCN treaties dealt with these issues only incidentally to international trade, merely as a byproduct thereof. On the other hand, conventions of establishment pivoted on such establishment provisions, hence their name. In the words of Professor and U.S. diplomat Herman Walker Jr., contrasting conventions of establishment to FCN treaties, here the context is different: investment rather than trade and shipping. Professor Herman Walker Jr. knew this well as he personally helped shape the format of the 1959 Convention of Establishment between the United States and France. Intuitively, states may have first catered for traders' rights and later on for investors' rights, as usually the first contact between two states revolves around commerce, and only at a more mature stage, nationals from one country begin establishing business in the other. Hence, in some instances, an FCN treaty may have predated a Convention of Establishment. However, at times, bilateral conventions of establishment were signed on the same date as FCN treaties, proving that the practice of negotiating these conventions was contemporary to that of concluding FCN treaties. For instance, the Treaty on Commerce between Switzerland and Italy of 1868 was concluded on the same day as their bilateral convention of establishment. On other occasions, the contents of conventions of establishment and Treaty on Commerce was contained in the same instrument. This was the case, for example, of the Treaty of Friendship, Commerce, and Reciprocal Establishment between Great Britain and Switzerland of 1855. Generally, FCN treaties may have preceded Convention of Establishment. Nevertheless, between the conclusion of FCN treaties and the negotiations of BITs, there was historically another step, a missing link, if you will, represented by these bilateral conventions of establishment, which undoubtedly inspired the formulation of bilateral investment treaties. Accordingly, it's fair to say that BITs descend from these conventions of establishment rather than FCN treaties. These conventions were not focused exclusively on foreign investments protection, though. They had a broader scope than BITs, covering, for instance, also consular rights, a subject now commonly dealt with in separate treaties. Yet, investment protection was already at the forefront in these earlier instruments, and so they planted the seed for nowadays BITs. The main object and purpose of Convention of Establishment is echoed in the preamble of every BIT. When France ratified the 1959 Franco-American Convention of Establishment, for instance, French Prime Minister Debré expressed his desire that the convention would have encouraged American firms to establish subsidiaries in France, rather than elsewhere in the common market. The French Minister of Finance went even to New York in May 1959 to reassure Wall Street that its capital would be safe in France. French Finance Ministry set up also a welcome center to encourage investors and thus attract foreign direct investments. The reason why conventions of establishment were not focused exclusively on investment protection lies with the intent of reaching a fair bargain between capital exporting and capital importing countries. While the conclusion of such conventions meant necessarily that both countries concurred on the mutual desirability of investment protection, in the case of a country having little or no capital to export, the legal rights accorded to foreign investors could have appeared on their face to constitute a lopsided deal. Indeed, only the nationals of the capital exporting country would have reaped the benefits of the provisions dealing with investors' rights. That's why it was deemed necessary to balance investment protection with other rights that capital importing countries' own nationals would have actually benefited from, such as visa or work permit to be able to work in the capital exporting country. In the face of the current criticism surrounding contemporary BITs and hinging on how they look after the interest of only wealthier states' nationals to the detriment of nationals of the least wealthy states, these ancient bilateral conventions of establishment may still have something to teach us in terms of getting to a fair deal. Some of the typical substantive standards of protection of BITs can be traced back to these bilateral conventions of establishment. This includes, with exactly the same wording, the full protection and security standard, see for example Article 6 of the 1868 Switzerland-Italy Convention of Establishment, or the fair and equitable treatment standard to be found at Article 1 of the 1959 Franco-American Convention, or the prohibition of expropriation without compensation as found in Article 4 of the 1951 Convention of Establishment between France and Italy. Drafted in a period of more liberal economic policies, straddling the dawn of the Second Industrial Revolution and the aftermath of World War II, some of these conventions offered at times even higher guarantees with respect to foreign investments when compared to some BITs. This includes, for instance, rights to market access and unfettered national and most favored nation treatments. Conventions of establishment were not concluded just between European states, like the Convention of Establishment between Greece and Switzerland of 1927, or between European states and American states, like the 1959 Franco-American Convention. Geographically speaking, these conventions were far-reaching, with some of them concluded between African states, such as the Convention of Establishment between Morocco and Senegal of 1965, or between European countries and African states, such as the Convention of Establishment between France and Senegal of 1960. Or between European countries and Asian countries, like the Convention of Friendship and Establishment between Spain and Iran of 1957, or the even older 1934 Convention of Establishment between Switzerland and the Empire of Persia, today's Iran. Thus, these conventions of establishment, with overlapping objects and purposes and interchangeable provisions with existing BITs and geographically far-reaching, were and remain relevant for the protection of foreign investments to the extent that they are still in force or not expressly superseded by other BITs. Overlooked or forgotten by contemporary literature and arbitral practice, these instruments are a secret weapon for foreign investors. Why are these international conventions so important today? Bilateral conventions of establishment could be used in conjunction with BITs to supplement or extend the investment protection provided by the latter. These conventions may come into play either by operation of the most favored nation, MFN clause, or by virtue of Article 31(3)(c) of the Vienna Convention on the Law of Treaties. Namely, by operation of the broadly phrased most favored nation clause, often found in many bilateral convention of establishment, these instruments can be used in combination with their more modern versions, the BITs, to attract the latter's dispute resolution mechanism, notably investor-state arbitration. Such an operation would be in keeping with the 1978 ILC draft articles on MFN clause, the jurisprudence of the International Court of Justice, and arbitral precedents. Following the maxim expressed by the French Court of Cassation in 1913, an MFN clause of a treaty can attract the more favorable procedure contained in another one, provided that both treaties cover the same subject matter. As illustrated, bilateral conventions of establishment cover the same subject matter, investment protection, as their fellow BITs. Therefore, the MFN clause of a convention of establishment can invoke the more favorable provisions contained in another BIT, and vice versa. In addition, these ancient conventions may become relevant by virtue of Article 31(3)(c) of the 1969 Vienna Convention on the Law of Treaties, according to which any relevant rules of international law applicable to the relations between the parties shall be taken into account when interpreting the meaning of a treaty. In conclusion, every time there is no directly invocable BIT in force between the foreign investor's home country and the host country, an applicable convention of establishment could be used in conjunction with BITs entered into between the host country and the third states to extend the investment protection provided by those BITs, by virtue of the MFN clause contained in that convention of establishment. On the other hand, where there is a BIT in force between the two countries offering lower protection than an applicable convention of establishment, that BIT's protection may be supplemented by the investment-related provisions of the applicable convention of establishment by means of Article 31(3)(c) of the 1969 Vienna Convention. Finally, in those instances where there is a BIT in force between the two countries offering lower protection than a convention of establishment entered into between the host country and a third state, the BIT's protection may be supplemented by the investment-related provisions of that convention of establishment by virtue of the MFN clause contained in that BIT. This is why the rediscovery of these long-forgotten international instruments may have a huge application in contemporary arbitral practice. Bottega di Bella, empowering your international rights.